नमस्कार। यतो धर्म स्ततो जय. Where there is justice, there is victory. This is the ancient Indian philosophy from the times of the Mahabharata. This, ladies and gentlemen, is also the motto of the Honorable Supreme Court of India. Yato dharm stato jay. But in today's India, where you have close to 5 crore cases pending in various courts, 87% in lower courts, some more than half a century old, are we following that principle of Yato Dharm Stato Jay? With me is the Honorable Union Minister for Law and Justice, Kiren Rijiju. He occupies that chair that was once occupied by Dr. Bhimrao Ambedkar. And I want to begin by asking you, Minister, are we today living by that principle of Yato Dharm Stato Jay with these many pending cases?
Thank you very much. Absolutely, we are following the same path, and that is our ultimate goal also. And there should not be any deviation from the basic objective for which the system has been set up, which is prescribed in the Constitution of India. And as a law minister of this country, I'm absolutely very clear about my duties and obligations, and we are following that dharma.
Sir, when you say we are following that dharma, what we hear is confrontation between the government and the Supreme Court of India on multiple issues. Would you want to tell us more about this confrontation? And it's on multiple issues, sir.
Well, Gaurav, it will not be appropriate to use this word confrontation. In a democratic setup, there are differences of opinions and positions. Even my position can have a difference of opinion with my other colleague. So, between the different organs like judiciary, executive, and the legislature, there will be issues which will run against each other's ideas. But to say that there is a confrontation, that is not correct. And I can tell you, our government from the day one has been absolutely clear in terms of giving space to judiciary, maintaining the independence of judiciary, as well as strengthening the Indian judiciary, which you talk about the large numbers of pending of cases. It is our endeavor to ensure that courts are well equipped. And in different occasions, I can explain in detail how are we getting the courts of India well equipped with the modern technology, with the support of all the system in place. But there are various issues. But right now, I want to stress that there's no confrontation between the judiciary and executive. If there are any perceptible, it's not because of the government.
Sir, that's a big point. So if there is, you're saying it's not confrontation, there are issues. Let's take this one by one, and let's specifically talk about names that the Supreme Court collegium may send to you. And they may reiterate a name, and yet it's not accepted. Is that a confrontation? Is that an issue?
First of all, let me clarify. It's very important to make the stand and the position very clear. Appointment of judges is not a judicial work. It is purely administrative in nature. If there are names which are sent by the Supreme Court or the High Court collegium for the appointment as the judges, it is the bounded duty of the government to carry out due diligence. Otherwise, I will be sitting there as a postmaster. Secondly, if you go back to the Constitution itself, the appointment of the judges is the duty of the government. Means the President of India shall appoint the judges of the Supreme Court and High Courts in consultation with the Chief Justice of India and the Chief Justice of the respective High Courts. There is no role of the judiciary as such to initiate and to give the finalization of the appointment of the judges. It was only later, because of the misadventure of the Congress party, the Supreme Court started acting, which is some people described as judicial overreach. then the collegium system came into existence. But right now, our position is very clear. Collegium system is in place. As long as new system is not introduced, we will follow with the collegium system, but the appointment of the judges cannot be done by the judicial order. It is purely administrative.
Let me then come to one more specific. A certain name is recommended by the collegium. It is sent to the government. The government does not approve it. It's reiterated by the collegium. If this is an issue and not a confrontation, as you insist, Minister, what's the way forward? What's the solution?
See, I don't want to talk about the individual names and why the appointments are not taking place in the case of particular names. It will not be wise also. These are very sensitive matter. And the Supreme Court collegium knows it very well. I have made my position very clear. Government stands are already known to the collegium members. And we also know why they are insisting on certain names. But let us not bring into the public domain about appointment of the judges of the Supreme Court and the High Court, because it will not be appropriate. I could have answered it, but I feel that it will not be appropriate to go to the names.
You could have answered it, but you choose not to put some information out in public domain. However, the Supreme Court did. It put out certain information in public domain, including certain intelligence reports. Is that transparency? Is that transgression? Is that a challenge?
We must understand that Supreme Court or any court has its own limitation. They are there to deliver judgment, to deliver justice. They are not like the government, which has all the resources to get informations and make opinion. If government takes a call, it is on the basis of certain informations and inputs. If tomorrow a particular sensitive inputs of the RNW or IB or any other agency is to be put in the public domain, then what is the sanctity of carrying out such a great effort in great secrecy in the interest of the nation? As a name comes to me for Supreme Court judge or High Court judge, there are numerous complaints invariably comes and attached with that name. Do I make it public? No. Right now I have some names with me, and every name has lots of complaints by the colleague judges, by the public, by the association, by the bars. I don't make it public. If a judge has written an adverse comment against any other judge, I am not supposed to make it public. There has to be some probity in the public life, some discipline, some sensible attitude by the people who sit in the responsible positions. So I'm very, very, mindful of my responsibility. I will never, ever divulge all the informations in the public forum which is not going to help for the purpose for which we are sitting there.
So you're saying you have the last word. The government has the last word on appointment.
I'm not saying it. Constitution says so.
Sir, let's then move to another aspect, which is same-sex marriage. Recently, the Supreme Court referred it to a larger bench, a constitution bench. Is that something that is to be decided by the Supreme Court, or legal sanction or law is to be decided by Parliament?
This is a matter, again, I leave it to the wisdom of the people of the country, who reflects the thinking of the country. It is the Parliament. Parliament is the reflection of people's idea, people's vision, and people's choice. We have the representative people sitting in the Parliament, which covers all the part of the territory of India. Supreme Court has its own authority. We are not supposed to encroach upon each other's territory. But the matter which you talked about, an institution of marriage, how India should govern in terms of taking care of various aspects of the civil actions, requirements, marriages. This has to be debated in the parliament. And if any law passed by the parliament is not following the spirit of the constitution, the Supreme Court has the option to alter that thing or pass a adverse judgment or refer it back to the parliament. But that too, if it finds that it is not in tune with the spirit of the Constitution of India. Supreme Court is the final arbiter of anything. And under Article 142, they can refer anything and pass a judgment that is law of the land. But when it comes to policy, we have to understand that India is a democracy. A democratic country has its own setup. So it is not only the Minister of Law and Justice who has to give an opinion on this. It is for all the political parties of the country, more than that the people of India will decide how our future should be governed.
Are you then, Minister, saying everybody, executive, legislature, even judiciary, everyone has to be accountable and no one should cross the Lakshman Rekha?
Accountability is one issue. The Lakshman Rekha is another issue. Accountability of judges is something which I am getting lots of feedback, suggestions these days, because judges are not accountable, you know it. Many people have suggested also that along with the National Judicial Appointment Commission, it should be National Judicial Commission to regulate the conduct and the process of how courts are maintained, ruled, or how judges are conducted. So there are various suggestions. I am not going to talk about any particular suggestion or any particular thing, but in general it's coming to me. We all are accountable. Parliament runs under rules. There are rules of business. Assemblies, government functions under rules of business. But in the court, there are no rules. There are practices which are being changed from time to time, and the Chief Justice, as the master of the roster, conducts certain thing. As far as the holidays are concerned, judges are going for holidays and all. So these are not exactly decided on the basis of rules framed by the parliament, but these are on the basis of the convention and the practice adopted by the Supreme Court and different high courts. That is why the holidays of different high courts are different from each other. It's not uniform.
You're seeking uniformity there because there is an issue about the number of holidays that the judiciary takes. Is that also a reason why pendency rises to 5 crore amidst talk that government is the biggest litigant? Government should reduce the number of cases government files.
Look, this is a very sensitive thing. Last time there was a question in the parliament. Question was very pointed that why judges are going on holidays and they keep going for holidays every break. I, as a minister, responded to that. But next day in the newspaper, the report carried that law minister said judges should not go for holidays. And there was a heartburn in the judiciary. They said, why law minister wants to stop the holidays of the judges? I did not say it. What I'm saying is, definitely while the court is on vacation, the cases will come to a halt. It's a fact. It's not I'm stating it. Definitely there can be some regulation, but I am of the opinion that judges require holidays because from the morning to evening they sit and they deal 50, 60 cases and constantly they are dealing every day. And also they are performing certain administrative roles. I will come to that administrative part little later. But due to their constant engagement with the judicial work and administrative works, they have a huge mental pressure. They are required to release those pressure by going out with family and all for the vacation. Absolutely okay. Because you have to understand, in United States or any other democratic countries, the judges deal with 4 or 5 cases at the most in a day. Here, a judge deals with 50 to 60 cases. Sometimes I have seen some judges deal with more than 100 cases, especially on the miscellaneous days and all. So after dealing with so much of heavy loads, they definitely require holidays.
Okay, fair enough. One such case that they've also dealt with is the issue of appointment of the election commissioner. They say the Prime Minister, Leader of Opposition, and the Chief Justice of India. What's your take on this? This is now the law, but is this the Lakshman Rekha being transgressed, or is this something that you will do something about, bring a law on this?
First of all, the appointment of the election commission is well prescribed in the constitution. Parliament has to enact a law. Accordingly, the appointment has to be done. I agree that there is no enactment in the parliament for that. There is a vacuum. But remember, the matter came to the Supreme Court not because of the disputes. Some people filed a petition, PIL, and then Supreme Court took a suo motu cognizance of the matter, and the constitution bench was constituted. I'm not telling what will be, the repercussion or what government is going to do, but what I'm saying is, I am not criticizing that judgment of the constitution bench, but what I'm saying is, if the Chief Justice of India or judges of India sit on every important appointments, who will carry forward the judiciary work? There are so many administrative matters in our country. So we have to really see that judges are primarily to deliver judicial works. They are there to deliver judicial order, thereby giving justice to the people. If they get into administrative work, then they will have to face the criticism. Suppose you are the Chief Justice or you are a judge. You are part of an administrative process. That will come into question. The matter comes into your own court. Can you deliver judgment on the matter which you are part of? You cannot. The principle of justice itself will be compromised. That is why Lakshman Rekha, what I talked about, is very clear in the constitution. And I am sure everybody will agree that government, our government, I'm talking about our Modiji's government, we have never taken any action to undermine Indian judiciary, or we have not encroached upon the territory which is under the domain of the Indian judiciary.
Sir, you say the Narendra Modi government has done nothing to undermine the integrity of judiciary. However, it is being said that democracy is under attack, judiciary is under attack, institutions are under attack. Recently at Bhubaneswar, you said that there appears to be a calibrated attack from outside and inside. What do you mean by that, sir?
I think that needs a little elaboration because that is very critical. And not only critical, I feel this is the most important topic for me, for the nation. When I was addressing the conference of the lawyers, the Supreme Court judge and High Court judges were also there, I said in a very clear term, anybody, if Rahul Gandhi or anybody says that Indian judiciary has been hijacked or democracy is over in the country, the judiciary is dead, what does it mean? There is a calibrated effort to undermine Indian judiciary. That is why day in, day out, they are saying that government is trying to take over Indian judiciary. What kind of statements and accusations are these? So in a way, it is a very sinister design. Our judges are not weak. Indian judiciary is not weak. But by constantly telling that judiciary is being hijacked by the government, or government is trying to take over Indian judiciary, that itself is a huge blunder for anybody who makes such statement. And I'm telling you, I got some message from United Kingdom. They are saying that it is very sorry state of affairs that the judiciary has been undermined by the government. And the members of parliament are not allowed to speak in India. They don't know India, but it is the fault of those people who are passing on this misinformation campaign. So, Gaurav, you have to understand that the person who speaks the most he is saying that he is not allowed to speak. This is most unfortunate in India. जो सबसे ज़्यादा बोलता है, वो बोलता है कि उसको बोलने नहीं दिया जाता है. ये तो हमारे लिए ठीक नहीं है, परिस्थिति ठीक नहीं है.
लेकिन वो बोलते हैं कि जो बोलते हैं वो एक्सपंज हो जाता है. मतलब अगर 40 मिनट या 50 मिनट बोलने भी दिया, एक्सपंज कर दिया.
पार्लियामेंट में तो रूल से बोलेंगे तभी तो आपका रिकॉर्ड में रहेगा. कोई राजा नहीं है जी इस देश में कि पार्लियामेंट में जब चाहे खड़ा करके आप भाषण देगा. सब MP 543 MPs इन द लोकसभा आर इक्वल. नोबडी इज महाराजा देयर. वो चाहेगा कि मैंने देखा है इन 2004 to 9 he used to walk and the whole gang outside, drama all outside, oh our prince is going to speak, and then all clapping and all. Special time and special moments were created for one person. Is this a fiefdom of any individuals? The Indian Parliament is a sovereign authority we have. Nobody has extra territory within the Parliament. Every member is equal.
Fair enough. But tell me this, how is this a calibrated attack on India from outside and inside? When the law minister of the country says it's a very serious comment.
It is not only serious, but it is true. Because the anti-India forces in India and outside India, they use same language. Did you ever notice? Same language. Democracy is in danger. Human rights are non-existent in India. In India, we all know very well in today's time, you can't hide anything. These people, whatever they say, these so-called anti-India gangs, same language is used by Rahul Gandhi. You see, you just compare it. I'm not saying it. You go back from this discussion and you see by yourself. Same language.
He's a senior member of parliament. A senior member of parliament, and you were saying that he speaks the same language as anti-India gang?
Not only the same language, whenever he speaks, that is being propagated and it is being publicized with a louder voice by the same ecosystem. The same ecosystem is working inside India and outside India also. Remember, people of India are with Modi ji and with our government. We will not allow this Tukre gang to destroy India's integrity and our sovereignty. Very firm about that.
Sir, as Law Minister of India, you're saying that there is a Tukre gang. Yes. And an opposition MP is in sync with this so-called Tukre gang, as you're saying.
Because I am not going to divulge so many other things. How fundings are being done from outside. How they are being organized. Who are the people who organize events in London or elsewhere? Recently, there was one seminar. I was not aware of the seminar in Delhi. Some retired Supreme Court judges, some senior lawyers, some people were there. The topic of the seminar was accountability in judges' appointment. But the discussion whole day was how government is taking over the Indian judiciary. Remember, I have excellent relationship with the Chief Justice of India, the present one, the past one, all the Supreme Court judges. I have a fantastic working relationship with all the Chief Justices of the High Courts and other senior judges. There's no problem. It is a few of the retired judges, few, maybe 3 or 4. Few of those activists, part of that anti-India gang. These people are trying to make Indian judiciary play a role of opposition party. Some people even go to the court and say that, please rein in the government. Please change the policy of this government. These people want Indian judiciary to play the roles of opposition party, which cannot happen. Judiciary is neutral. Judges are not part of any group or political affiliations. How can these people openly say that Indian judiciary must take head-on with the government? What kind of propaganda is this?
Sir, if there is a violation of the law, you, the Law Minister of India, Narendra Modi government has been in power for 9 years. What action, if any, is being taken against those you describe as Tukre gang?
actions will be taken, actions are being taken as per law. But if I say that I will take action, the agencies will take action as per the provisions of the law. Nobody will escape. Don't worry, nobody will escape. Those who have worked against the country will have to pay a price for that.
But you will engage with the opposition. And while we are on this topic, now 9 years of your government being in power, there were three main issues that the BJP stood for. The Maryada Purushottam Shri Ram Mandir at Ayodhya, Article 370 in Jammu and Kashmir, and the Uniform Civil Code. Are you moving forward in that direction with the first two having been completed?
Well, you are aware of our ideology, our manifesto, and what we are doing. About the Uniform Civil Code, 2 of our states have already constituted committee, and it's a work in progress. The parliament session is going on. I'm not going to talk about our position, but you are aware of our objective, our ideology, and our stand. I think that's enough.
लेकिन अगर यूनिफॉर्म सिविल कोड के ही इसी मुद्दे पर, क्योंकि कुछ राज्यों ने तो ऐसे कर ही दिया है, क्या 2024 के चुनावों से पहले आप इस दिशा में आगे बढ़ेंगे?
वही मैंने कह रहा हूँ कि मैं टाइमलाइन अभी बोलेंगे तो सारा जो मैंने अच्छे बातें बताई है वो गायब हो जाएगा. आप इसी को ही डिबेट में लाएगा और सारा देश में ये चर्चा चलेगी. वो मैं नहीं चाहता हूँ. जो महत्वपूर्ण मुद्दे जो मैंने बताया है वो मेरे लिए महत्वपूर्ण है. दूसरे बात आप पूछा नहीं, मैं एक नोट लेके आया. मैं सोच रहा था शायद आप पूछेंगे. मेरे लिए बहुत ज़रूरी है इसलिए बताना, क्योंकि आज इंडिया टुडे का कॉन्क्लेव है. ये बहुत इम्पोर्टेंट प्लेटफॉर्म है. कुछ चीज़ें होते हैं बाकी चीज़ों से बड़ा होता है. दीज आर वाइटल्स. आई वॉज अमेज्ड एंड मोर देन दैट aghast when a member of parliament stands in the house, inside and outside, and says that every state in India must be free to do whatever they choose to do. India is just a union of states. This kind of remarks is very dangerous for India's unity and sovereignty. That is why I thought I must read out this. This is small, just take 30 seconds. So Article 1, Clause 1 of our Constitution says, India, that is Bharat, shall be union of states. Now, how this gentleman misinterprets this union of states. Now, this Bharat word is used in Mahabharata, Vishnu Puran, and all kind of old texture like Brahma Puran and all. One MP, one member from Tamil Nadu said it, Sri Kullur Subba Rao, during the Constituent Assembly debate. He said, Sir, I heartily support the name Bharat, which is ancient. The name Bharat is in the Rig Ved. It is said there, oh Indira, all this progeny of Bharata. Also in Vayu Purana, the boundaries of Bharata also are given. Secondly, what Ambedkar said, I'm just skipping other long points. Ambedkar, while making the final, presenting the draft resolution in the House, said, but I can tell you why the drafting committee used it, means the Union of States term. The drafting committee wanted to make it clear that though India was to be a federation, the federation was not the result of an agreement by the states to join in a federation. And that the federation not being the result of an agreement, no state has the right to secede from it. The federation is a union because it is indestructible. Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole. Its people, a single people living under a single imperium, derived from a single source. There are many important points I will not add on. So how this gentleman and his same mindset people are saying that India, every state must be allowed to take its own position on important issues. From the ancient time to now, even when the Constitution of India was being framed, it is very clear the states are divided only for the administrative convenience. And the gentleman and his people are spreading the hatred to divide India from one state to another state. It cannot happen. So when the Britishers left India, they sowed certain seeds, some kind of a division in the society, because they lost India. So here, because somebody has lost the power, does he enjoy right to divide India? This will not happen.
So you are saying that your government will counter all the measures that Rahul Gandhi is saying that democracy is dead or dying here in Parliament and on every platform in the run-up to the next elections? Is that your big platform?
When a person gets into the mode of a frustration, he may utter many things. We are not bothered about what happens to Congress party. If Rahul Gandhi is responsible for the destruction of Congress party, we are not interested in that. But when he makes a statements, when he says something which affects adversely on India's image and prestige, we have to react it. After all, he is a member of parliament and citizen of India. That is why I don't think that we are responding to somebody just like that. We are responding only when it affects our system, our parliament, our constitution, our nation. We are very clear about that. That is why I don't mince the words. We are very simple people and we work for the nation. And finally, I have never stated this thing before. I'm saying today in India Today's Conclave for the first time. When I came from Arunachal Pradesh to Delhi, I was excited, but I was sad. Why? Because when we were there in the border, we just knew about Jai Hind, Bharat Mata Ki Jai. India is our nation, our Tiranga, our tricolor. When I came to India, when I encountered some group of people who are saying that freedom of expression, for anything you can even abuse the nation, these people get protection. We never heard of this kind of thing. So that is why India is able to survive, because there are good people who are ready to sacrifice anything for the sake of India's unity, its sovereignty, despite some gang members hell-bent on destroying India. So I am very clear about that. I come from a very sensitive border state. Prime Minister has given me a responsibility of taking care of a very sensitive department. We are serving the nation. We will continue to serve the nation. While serving the nation, if anybody comes on the way to destroy India's image, India's prestige, we will deal with that also.
Minister, very, very strong words, but spoken from your heart, and the 20th India Today Conclave, for joining us here on this platform. Thank you very much and wish you all the best in your endeavour, sir.
Ladies and gentlemen, raise a warm applause for the Minister. Mr. Rijiju, sir, I'd request you to stay on stage while I call upon Mr. Anuj Kohli, Hitachi Technology, to come up on stage and present a very small token of our appreciation to the Minister. Once again, ladies and gentlemen, please raise a warm applause for Kiren Rijiju, Union Minister of Law and Justice. Thank you, Minister. On a side note, ladies and gentlemen, for those of you who missed the session with Brad Smith, Vice Chair and President Microsoft yesterday, on everything with ChatGPT, AI related, you can catch the session. We are playing it right now at the Shah Jahan Hall. And of course, our next edition of our magazine, India Today, will carry encapsulating all the highlights of what has gone down in the 2 days at the India Today Conclave in its 20th edition. With that, I want to quickly move into our next session this afternoon, setting precedent. Who gets to judge the judges? Arguments and counter-arguments. To take it from here, I'd like to invite on stage our session's moderator, Rajdeep Sardesai, Consulting Editor, India Today Television.
Hello and welcome once again to the India Today Conclave. Few, if any, constitutional posts at the moment in the country carry the weight of public expectations and the microscope of public scrutiny as much as that of the Chief Justice of India and, dare one say, the Supreme Court itself. Not a day passes when the apex court doesn't make the headlines in some form or the other. So how do those who have worn what some might argue is now a crown of thorns see the role of the Supreme Court and the Chief Justice of India in particular? Today we'll be listening to three Chief Justices of India, two former recent Chief Justices and the current Chief Justice in the course of this day. Please therefore welcome our first guest, Justice S.A. Bobde, Chief Justice of India from November 2019 to April 2021. Justice Bobde, welcome to the India Today Conclave. Am I right in suggesting that the Chief Justice's post today is a crown of thorns, constantly under scrutiny and therefore seemingly under immense pressure as well?
Well, the thorns, if any, are poked by the media.
I see.
It is a difficult place to be in, the Chief Justice of India. But, and it is a heavy responsibility. There's too much competition for the court's ears. And obviously everybody wants to win his case. But I'm saying this frankly, without any disrespect. The problems really arise from the somewhat irresponsible comments judges have to face. And the Chief Justice is always answerable. Anything that happens in the court is the Chief Justice who is responsible.
Now, you seem to be almost suggesting that Bechara Chief Justice.
No, not at all.
You know,
I was just telling you, just carrying forward your analogy of thorns.
Yes.
I said the post itself, there's no thorns on the post. Those thorns are what you get from the onlookers.
Okay, the onlookers will probably turn around and say that the fact is many judgments in this country at the moment are tangled in political wars. You were, for example, part of the Ayodhya judgment. And the nature of the case, the kind of politics that had swirled around Ayodhya for decades meant inevitably whatever judgment you delivered, there was going to be some kind of a political fallout to it.
That's so in every case.
But is that part of the problem, that because the Supreme Court today increasingly finds itself tangled in taking up these political cases, whether it is Rafale, whether it is the Ayodhya judgment, because these cases come eventually to the Supreme Court, the court almost inevitably, and the Chief Justice inevitably finds himself caught in a political battle?
Well, I would like to say that the word label political can be attached to anything. I see nothing political about the Ayodhya case. The case, what we heard. There is probably nothing political about Rafale. It was a defense deal. Ayodhya was an issue about whether Lord Ram, amongst other things, Lord Ram was born in that place, etc., etc., etc. So I don't see, and the case has been going on since, the problem has been going on since pre-independence times. What is political about it except that politicians talk about it? Or some might want to derive political mileage from a controversy. We are not involved in politics as courts. We decide a case that comes up before us, brought to us by parties who have something to say and who have a claim, and we adjudicate that claim. What is politics in it?
So you didn't feel extra pressure while you all were hearing and eventually delivering the judgment in a case like Ayodhya?
No. Possibly a greater sense of, possibly some sense of anxiety on what effect it might have on the body politics to some extent, but not the political kind.
The reason I'm saying this, sir, is that there is a huge question mark over whether the Supreme Court is truly independent today. And that includes truly independent.
Independent of what?
Independent of executive interference or executive pressures. I quote a senior Supreme Court advocate, Dushyant Dave, he's also headed the Supreme Court Bar Association, said judges are scared of the Modi government and reluctant to rock the boat.
Well, I don't think I should respond to his views. I mean, they're entitled to his views, but I do not see any executive interference in the judicial process. I did not experience any. You could ask, you've invited other colleagues of mine today, you could ask them. You see, the way the executive can interfere is by having benches suitable to it in each case, and that doesn't happen. The benches, the roster is prepared by the Chief Justice of India, independent of any pressures.
But that itself has become contentious over times. You know how 4 judges staged a few years ago a remarkable press conference, an unprecedented press conference, where they questioned the manner in which allegedly bench fixing might have been taking place.
That press conference, I am not aware of the allegations of bench fixing, though there was something about the preparation of rosters.
Yeah, questioning over the role of the Supreme Court Chief Justice as master of the roster.
That, to my mind, is one of the most unfortunate events in the history of the Supreme Court of India. And I tried my best to see that it doesn't happen. And thereafter, I am saying this because some magazine has already written about my role there. And I did try to bring about a peace between the opposing points of view. I succeeded, party didn't succeed, but it's an unfortunate event. I don't want to, I don't support, I wouldn't have done it myself.
You believe it's an unfortunate, you're saying something important. You believe it's an event that should have never happened. It's an unfortunate event. You don't subscribe to the way it happened. Let me give you examples, since you say you don't want to respond to what an individual advocate's opinion is. Habeas corpus petitions of those who were arrested, for example, in Kashmir, after the setting aside of Article 370. They were kept pending for months. You didn't touch the electoral bonds issue, sir, which again is politically a hot potato. All of this is being interpreted to suggest that the court and the Chief Justice's office unwilling to take on the government. People were for months in jail, sir, under the Public Safety Act in Jammu and Kashmir, habeas corpus petitions filed, and the Supreme Court of India does not see urgency in that matter?
I don't think they were kept pending deliberately as you people see it or anybody else sees it. And one thing I must tell you in this context, I believe, and it is said to be a law of how the human mind works, and that law is that a suspicious person always finds what he's looking for. It is true in the domestic front, it is true in politics, it is true in the executive, it is true in the media, it is true everywhere. You always find what you're looking for.
I'm only giving you a reality, sir. Hundreds of innocent people possibly were in jail for months. Habeas corpus is the basic right that I have under the Constitution.
First of all, it was during the pandemic.
Yes.
It was during the pandemic. It was difficult to get matters heard. I can tell you, I was not ready for this question. I can tell you hundreds of cases where the courts wanted, asked parties, would you like to hear? And parties said, no, we cannot appear. Advocates said they cannot appear. And it happened that there was something about the CAA matters were also pending then.
That's right.
And they wanted those to be heard. Now that involves allowing 500 to 600 advocates to enter the courts. That was not possible. And some of them said, no, we want our matters tagged, we will not get them untagged. But frankly, I would have liked to answer this question with statistics, which I am not ready for.
Okay. You were Chief Justice also, sir, during the contentious, I'll come to COVID later, during the contentious farmer agitation. And you stayed the implementation of farm laws until further orders. Now, traditionally, the Supreme Court, sir, has been very wary of passing interim orders that stay laws passed by Parliament. And yet you did so.
Yes, I did.
Were you aware again that, like it or not, you were stepping into a political minefield? You see, the court seemed to be stepping into a political minefield. The media reacts and then you say, oh, the media is dragging us into...
political minefield? There was a law before us.
Yes.
There was a challenge to a law before us.
Yes.
We were seeking the government's response to the challenge. We were reading stories and watching stories on the television about people attacking each other, forces attacking each other, people jumping onto the Red Fort on the Independence Day, I think. And
Republic Day.
Republic Day. So many violent instances. I had stated to the other side, I stated to the government, why don't you consider doing this? Why don't you consider withholding the laws? Because look at the consequence. There is a law on one side and there is a large-scale violence on the other side. What is important right now? And there was no response. So I consulted my colleagues and we were all of the unanimous opinion that this should be stayed. What's political about it?
Okay.
There was no election in the offing. And anyway, we have nothing to do with elections.
And you're very clear, at no stage has the judicial process been influenced, therefore, by the executive during your tenure.
Yes.
Okay. The tangle between the executive and judiciary, sir, over appointments. You were Chief Justice for almost 18 months. And during that period, not a single Supreme Court judge was appointed.
Yes.
Because the collegium system could not arrive at a consensus.
No, it is not because of the collegium system. It is because as a collegium, we were unable to arrive at a consensus. It is not because of the system. It is because we failed as a collegium to arrive at a consensus about the names.
Because a particular...
Or in some cases, about the order in which there should be an elevation.
Because there was a particular judge in your collegium who insisted that Justice Akhil Qureshi be elevated to the Supreme Court. The government didn't want his name.
Akhil Qureshi was one of the judges who was not appointed. There were many who were not appointed.
That's right.
They were all appointed afterwards.
But for 18 months, we did not have a single appointment to the Supreme Court.
Yes. So,
what does that suggest?
There have been periods when you haven't had elevation for 2 years. You haven't had elevation for longer. What is so extraordinary about this? We couldn't arrive at a consensus. It can happen in a human institution.
Do you believe, therefore, that there is a need to relook at the system as it exists? Why should judges, 5 brother-sister judges, sit together and decide on who will be who will be their fellow judges? Should the executive have a greater say, as the executive seems to want? The law minister seems to be running a campaign calling for a review of the collegium system.
Let's not go by the government of the day, the law minister of the day, or the chief justices at the collegium of the day. I'll tell you what my perspective is.
Sir.
My perspective is that under the Constitution of India, there are 3 organs of government: the executive, the legislative, and the judiciary. They are separated in their functions and powers. They are not separated in their purpose and objective. The objective of all three has to be the common objective set out in the Constitution in the preamble. I consider it perfectly legitimate that the executive has a vital interest in who is going to be a judge. Apart from the fact that they are the executive and one of the organs of government, they are also the largest litigant in any court. Now the problem is not that they have an interest in it. The problem is how to give effect to that interest. Earlier, it was only the Chief Justice of India who decided it along with the government. Sometimes the Prime Minister, the executive, the law minister. Then came the two judges case. It was widened. The Chief Justice of India's power was shared with the collegium. Power and responsibility. It was also, you brought in more fresh views on the same elevation. Then came the parliamentary law NJA, National
NJC.
Judicial NJC. That provided a wide representation to all kinds of opinions, including to social workers, eminent people. The Supreme Court did not agree with it, and they struck down that law. They also struck down the constitutional amendment on the ground that the independence of the judiciary expressed through the appointment of judges is a part of the basic structure. So there was no say to the executive formally. And that is as it is at the moment. Neither
You support that?
What?
You believe that the executive should have no say
No,
in the
I
appointment?
don't support it. I started by saying that they have a vital interest in the...
Should they have a veto power?
No, they shouldn't have a veto power. The primacy of opinion must be that of the judiciary. The reason is, we know what is the caliber, the merit and the suitability of the judges who are to be elevated. We have seen them right from the days they were lawyers. We have heard appeals against their judgments. We know how they think. We are best positioned to see which judge is meritorious. But those judges of the superior court, we are only talking of superior courts, because in the 70% of the judiciary, the public service commissions appoint them, which includes the government.
Yes.
We are only talking of High Court and Supreme Court. These courts, these judges have to take an oath of office. That oath of office says that I shall uphold the sovereignty and integrity of India, that I shall uphold the Constitution and the laws, and other things.
Yes.
It is important that a judge can do that as a judge. And on these aspects, it is often the executive's opinion which is vital. For instance, when the Intelligence Bureau reports to us, things like what are the activities of this judge. Now, you imagine a situation, a gross case, where one of the candidates is of the opinion that India should not be a sovereign entity like it is. There should be a separate state somewhere. Separate means outside India. The executive is in the best position to tell the court that this is not a suitable candidate, the collegium. So the executive's opinion is important. With or without the NJC, I have full respect for the judgment of the Supreme Court. I am saying that consultation with the executive can be made by the Chief Justice of India and the collegium. Their views taken, but I believe the primacy must remain with the Chief Justice or the collegium.
Okay, I think you've been pretty clear, categorical in that sense now about that. Consultation, but the final say must remain with the collegium is what you're telling me.
And consultation, I do not mean concurrence.
Okay, point taken. So we have very limited time left, but I'm going to ask you some more. Let's lighten the mood. The most difficult case in your career?
It's a case I didn't decide, but I'll tell you some. I mean, there was a laborer who was charged with rape and murder of a young girl.
Yes.
And and that chap had been convicted. When the appeal was pending, the investigating officer committed suicide, saying that I have been forced to implicate this chap. And he managed it successfully. The High Court agreed that his suicide note is true. And we were hearing an appeal. Obviously, he ought to have gone scot-free. This is Lalit, the expert in criminal law. But I took the view that we should not acquit him till we prosecute these prosecution witnesses who had lied through their teeth. And there was a difference of opinion between my colleague and me. He said, no, we'll just let him go. I said, no, we must prosecute him. Fortunately, unfortunately, the bench changed. And I couldn't decide that case, but I have never been so foxed in a case as in this one. Because the suicide note was not part of the trial record.
It's interesting you're saying that, because your one judgment did create a lot of controversy, where you, not judgment, but an observation you made in court, where you suggested to a rape victim that she marry.
I didn't.
This is what was reported.
I'll tell you what happened.
That she marry her alleged rapist.
Frankly, I want to tell you what happened because I haven't got a chance to tell anyone what happened.
Please do.
The boy and the girl had a love affair. They were related to each other distantly. They had a love affair, and the parents on both sides objected because they were spending a lot of time together. So they told them, you get married. You can't carry on like this. They had an affair for 7-8 years. And they signed an agreement that we'll marry. Now that chap came in appeal. He applied for bail. And that woman then said that I'll prosecute you for rape because we've been having sex and you haven't married me. So that his bail was rejected. He came by way of a bail application before the Supreme Court. I told him that what is this matter? You've been living together and there is this agreement on record which you have signed to solve this family dispute.
Right.
And are you going to get married or not? That is what I asked.
Okay.
Just a minute. And then I rejected his bail application because they said, no, we have not married. I haven't followed this agreement. I rejected his bail application, and these intelligent people in society wrote to me saying that you must review your orders. Means what? Grant him bail. Absurd thing.
Okay, this is the danger of obiter dicta.
Yeah.
Making headlines. But my final question is, there was a nice picture of you on a Harley Davidson. We haven't seen too many CJIs on a Harley Davidson. You're a motorbike fan. We didn't know it till then. Any regrets about posing there in...
I wasn't posing. Somebody got that Harley Davidson. I sat on it. And there was somebody who had nothing to do with anything who took a picture and sent it to her lawyer husband.
Right.
And that is how it went around. I didn't ride it. I only sat on it, though I would have liked to ride it, I will tell you that. It was COVID times, a lot of, you know the rest. But frankly, I became very popular with the younger crowd.
You did. and you've also become very popular among judges because during COVID times, you brought in online technology to encourage more and more people to appear before court. It's now hybrid, and I think it's made a huge difference to the courts, and that will be one of your many abiding legacies, Justice Bobde. But thank you so much for joining us and giving us your perspective. Appreciate Justice Bobde there taking those questions. Thank you. Thank you, sir.
Ladies and gentlemen, as you raise a warm applause for Justice Bobde, may I please call upon Mr. Virendra Kumar Kasliwal to come up on stage. He's the Chief Financial Controller. Sir, just 2 minutes, sir. To come up on stage and present a small token of our appreciation to Justice Bobde.
It's not a Harley Davidson, don't worry. You have one. Wow. Thank you so much, sir. Okay,
Thank you, sir.
That's not it.
So Rajdeep continues with our next session. As he said, we have 2 former Chief Justices and the current there. So the next session, over to you, Rajdeep.
Our second Chief Justice is another very distinguished occupant of the post who served as Chief Justice for just 74 days last year, but whose tenure is marked by truly some remarkable achievements. Most notably, the manner in which more than 16,000 cases were listed and almost 4,000 of them were cleared within the first 12